So first of all, I would like to thank the Las Casas Institute and Hugo, his new director, and congratulate him for this appointment. And to present a little bit, the institute is very well known, but the Las Casas Institute takes its name from the 16th century friar Bartolomé de las Casas, who was probably born in Seville at the end of the 15th century. Bartolomé de las Casas was a champion of the rights of indigenous peoples in the Americas, as you know, all of you, and he enlisted the academic support of his fellow friars at the University of Salamanca to further this cause. Named after this renowned figure, the Institute conducts and promotes research into Christian humanism and its application to contemporary social issues. The Institute disseminates its research to wider society through conference, talks, books, and online resources. And one of the Institute's main research interests is human rights. Since becoming an associate member and subsequently a research fellow, I have endeavored to promote research, events, and publication in this field, which is in crisis worldwide, and unfortunately, we are all aware of. To this end, I am organizing a series of workshops for relevant European experts and arranging for their work to be published in an appropriate academic journal. The purpose of these workshops is to shed light on aspects of human rights protection in Europe and the challenges ahead if Europe is to continue to be considered the continent of human rights. Today's workshop is the second of two public workshops discussing 6 topics under the broad umbrella of the European challenge defending human rights in the digital age. Our conclusions will be published in a special number in a prestigious European studies journal, Cuadernos Europeos of Deusto, from the Deusto University. At the first workshop, which took place in May 2025, perhaps you remember, we presented the topics and the initial stage of our research. Today, we will present our conclusions before submitting our papers to the journal for publication. This event also marks the cooperation between the Las Casas Institute and the Thomas More Center on International Relations, which was created last year by my university, CEU Fernando III. I will now hand over to Hugo Slim, director of the Las Casas Institute, who will moderate this workshop and introduce each participant. I would like to thank them all again for accepting my invitation to participate in this activity. Hugo.
Carlos, thank you very much, and thank you for framing the event so well. That's great. And I think we'll just go straight to the speakers. And as Carlos said, you've been working since we met in May, or you all met in May. So the purpose of this is really to hear good summaries of your work so far. And so we know what to expect in the papers that you will then submit. So thank you, and thank you for being brief and just summarizing. And we'll go for 10, 12 minutes each, and then have a round table at the end. So Professor Carlos Fernandez Liesa, currently a member of the UN Human Rights Committee for the period 2025 to 28. It's great to have you with us, Carlos. And you are going to set us off thinking about sustainability and human rights in the EU. Thank you.
Good afternoon. It is an honor for me to share some thoughts on human rights in the European Union. Many thanks to Carlos Espaliú for promoting this activity. Also to Professor Hugo Slim, director of the Bartolomé de las Casas Institute at the University of Oxford. I decided to approach human rights from the perspective of sustainability. Sustainability must lead to a balance between the economy, ecology, and social issues. The relationship between those 3 factors is very important in my opinion. We can talk about sustainable development, sustainability, and even the principle of sustainability, the legal nature of which I will not go into here. In any case, it is a legal concept that predates the 2030 agenda and will continue to exist after it. The idea of sustainability is very important in the European Union. Since the 1970s, without an explicit legal basis, the European Union has developed an international environmental policy and turned this organization into not only a commercial and solidarity-based actor, but also a green actor. It lacks geostrategic muscle, which it still does not have, either military or in terms of energy autonomy. Furthermore, the European Union is the most advanced social model, and in terms of human rights, it has developed its own model. From the point of view of sustainability, the Treaty of Lisbon contains the following reference to sustainability, which make the European Union a sustainable actor. The preamble states that the European Union is determined to promote the economic and social progress of people, taking into account the principle of sustainable development. Article 3.3 of the treaty then addresses sustainable development from the perspective of the internal market. Article 11 of the Treaty of Functioning of the European Union states that environmental protection requirements must be integrated into the Union policies and action with a view to promoting sustainable development. The concept of sustainable development is referred to in Article 3.5 of the treaty in relation to external action. In short, sustainable development is a concept that is linked in the community order not only to the environmental but also to its social and economic dimension. Now we reflect on this aspect briefly. The concept of sustainability in external action is referred to Article 3.5 of 21(2)(d). Those article refers to sustainable development of the planet and in external relation in development question. No? Although there is no reference to sustainability in the commercial sphere in Article 2006 and 2007 of the Treaty of Functioning of the European Union. But a lot of trade agreements have included sustainable development in their provision. In practice, the notion of sustainability in these agreements does not refer to all aspects of sustainability, but fundamentally to labor and environmental standards in a restrictive view. As for the consequences of breaching sustainability clause, there are two types of agreements. One, some agreements like European Union Korea agreement have a dispute settlement mechanism, and the others, like the agreement with Singapore, did not include a chapter on dispute settlement on sustainable development, in which, according to the court, means that the European Union can suspend the application of the agreement by invoking Article 60 of the Vienna Convention due to not compliance by the other party. External action in favor of sustainability should also reflect on ascertain the legitimation of the European Union, which sometimes operates with double standards. Two, from the economic perspective, a sustainable world requires many changes, especially in terms of what the European Union has done in environmental regulation, ecological transition, and the decarbonization process. In any case, as Tomushat pointed out, the 2030 agenda is neutral with regards to any particular economic doctrine. The economic sustainability model is compatible with the market economy, although it is the least defined aspect of the agenda, and the least developed in international sustainability law. There are several initiatives in resolution of the United Nations General Assembly on social and solidarity economy, sustainable trade, circular economy, environmental protection, and so on. It should be noted that in the European Union, since the approval of the guiding principles on business and human rights in 2011, there has been significant progress. The European Union has sought to avoid fragmentation of the European market, and on those bases, it has adopted directives on sustainability reporting and on corporate due diligence in sustainability. We are witnessing a change in corporate culture towards respect for human rights and the environment. It is true, however, that as a result of the competitiveness gap between the European Union, the United States, and China in 2025, and the following the Draghi report, measures are being taken to promote sustainability in favor of competitiveness. Finally, the European Union is not doing very well in the social dimension either. On the one hand, we have the European Union Charter of Fundamental Rights for a quarter of a century now. It is a classic and complex charter which has some problems. On the one hand, it only refers to sustainable development in Article 37 from a purely environmental and classic perspective. On the other hand, there are aspects of the European Union that are not working well in terms of fundamental rights. To give two examples, on the one hand, European rearmament, on the other, migration pact focus purely on border control and not in question of human rights. Okay, apologize for having exceeded my speaking time. I hope you found it interesting, and I hope to be able to make an interesting contribution for the publication. Thank you.
Carlos, thank you very much. You were absolutely on the dot. So thank you. And thank you for introducing this important and, as you say, core EU concept of sustainability. And of course, the sustainability of human rights is the core challenge in many ways as well in the digital space. So thank you for that. And we're now going to go to Professor Susana Sanz Caballero. Susana, thank you very much for joining us. And you are going to talk about the fragility of human rights in times of law erosion. Thank you.
Okay, thank you very much. Thank you, Professor Slim and Professor Espaliú, for hosting us today. For next time, I volunteer to go to Oxford or to go to Sevilla. I met my husband in Oxford for the first time, so I have nice memories. And my son is living in Sevilla. He's a doctor there, so I would also love to visit the city. But I'm fine with the webinar. Okay, my contribution aims to demonstrate the intrinsic relationship that exists between the rule of law and the protection of human rights, showing how both values are being challenged today, both in the United States and in some members of the European Union. Due to the time constraint, today I will focus only on one specific element of the rule of law, namely judicial independence. And to respect my 12-minute slot, I will only touch upon one specific type of attack to judicial independence, which is harassment to justice. So rule of law and human rights are sides of the same coin. When the rule of law is eroded, human rights are compromised. And where human rights are violated, the rule of law is neglected. In light of recent global developments, it's legitimate to ask whether human rights can endure the ongoing assault on legal and democratic norms. The United States is widely recognized as the first modern liberal democracy, established with the adoption of its constitution and its Bill of Rights in the 18th century. But even before that, the Virginia Declaration had already laid down foundational principles of human rights and rule of law, such as the due process, equality before the law, limitation of arbitrary power, and government by consent. These instruments demonstrate the early and deliberate intertwining of fundamental rights and the rule of law in the American tradition. But we now turn to Europe. These principles are part of the Union's DNA. Article 2 of the Treaty of the European Union proclaims that the Union is founded on human dignity, freedom, democracy, equality, the rule of law, human rights, including the rights of minorities, as well as pluralism, non-discrimination, tolerance, justice, solidarity, and equality between men and women. The erosion of any of these values threatens the integrity of the entire European legal and political order. The European Union identifies 4 fundamental pillars of a robust rule of law system: judicial independence, media pluralism and freedom of expression, a strong anti-corruption framework, and effective balances. Each of them plays a crucial role in safeguarding human rights. Since 2020, the European Commission's rule of law reports have year by year reaffirmed that healthy rule of law regimes have to respect these 4 pillars. However, it is the Council of Europe that was pioneer in this field. Its 2016 rule of law checklist emphasizes that authorities must treat individuals with dignity and equality and allow them to challenge decisions before independent and impartial courts through fair procedures. This comprehensive framework is rooted in the European Convention of Human Rights, the European Social Charter, and beyond the Council of Europe, it's also based in the Charter of Fundamental Rights of the European Union that Carlos just mentioned before. And all this is supplemented by the International Covenant on Civil and Political Rights and the International Covenant on Economic, Social, and Cultural Rights. All this provides a benchmark for analyzing challenges faced by democracies, including the USA. At its core, the rule of law is about the control of power. Scholars distinguish between a thin approach focused on legal clarity and predictability of laws, and a thick approach, which requires laws to embody justice and human rights. This thick conception shows that the rule of law and human rights are indissolubly linked. For the rule of law to be genuine, laws must be democratically enacted and they must guarantee fundamental rights. Thus, democracy, the rule of law, and human rights form the 3 angles of the same triangle. Inconsistent application of these values within the Union undermines the internal legitimacy and also its external credibility. And the same goes for the US. As promised at the beginning, I will now examine only one of the 4 core elements of the rule of law, judicial independence today, and it's linked to the human rights most closely related. Judicial independence is not a privilege at all. It is not a privilege granted to judges. It is a necessity for citizens seeking justice. Judges make decisions that affect people's rights and freedoms. So when the judiciary falls under the influence of the executive, the right to a fair trial is severely jeopardized. In Europe, judicial independence is enshrined in Article 6 of the European Convention of Human Rights and Articles 47 and 48 of the Charter of Fundamental Rights. If judges follow governmental directives, equality and non-discrimination are compromised. Similar wrongful acts may be treated differently depending on political affiliation. Article 14 of the International Covenant on Civil and Political Rights guarantees a fair and public hearing by a competent, independent, and impartial tribunal. So any interference threatens judicial independence and consequently the separation of powers, which is crucial to the rule of law. Such interference will endanger rights linked to justice, such as access to a court, the right to a fair trial, defense rights, the presumption of innocence, the right to a motivated and reasoned decision, the right to appeal, and equality before the law. Yet, judicial conduct is not beyond the scrutiny. It is not that judges are above the law at all, because when impartiality is reasonably doubted, when it is at stake, mechanisms for recusal must exist, and parties will have the right to appeal or seek annulment. In cases manifestly arbitrary judicial adjudication, disciplinary or even criminal liability may be warranted. So let me now turn to a specific factor that compromises judicial independence and impacts human rights, which is the harassment of judges and contestation of judgments. Public discreditation of judges whose rulings displease the executive has become increasingly common both in the US and in the European Union. Harassing judges for their decisions constitutes clear interference in judicial activity. Such actions endanger several fundamental rights of judges, all of them protected by the European Convention of Human Rights and also by the International Covenant on Civil and Political Rights, such as the right to liberty and personal security, the protection from inhuman and degraded treatment, privacy rights, and freedom of expression. But beyond the individual impact, intimidation of judges also undermines the collective right to independent and impartial tribunals that societies have. Intimidating judges also weakens democracy by eroding check and balances, constitutional rights, and public trust in the justice system. In the United States, public attacks against judges whose rulings counter the executive's agenda have become recurrent. Examples include defiance of court orders in immigration or environmental cases, retaliatory complaints, and even calls for impeachment of specific judges. These attacks are different types of indirect intimidation that sometimes amount to lawfare. But these incidents, there are also incidents of real-world harassment, such as the anonymous pizza deliveries to judges' homes, as in the times of the mafia, and more recently, the controversial arrest of a judge accused of obstructing agents during the detention of a migrant person at a courthouse in Milwaukee. If we turn to the European Union, similar patterns of intimidation can be found, notably in Poland and Spain, but also, as far as I know, in Hungary and Romania. In Poland, the former government led by the Law and Justice Party implemented until 2023 judicial reforms that triggered serious concern. The executive orchestrated a campaign against judges who opposed arbitrary changes or issued rulings that displeased the executive. And the European Court of Human Rights was particularly firm in condemning such interference. Special mention deserves the case of the former spokesperson of the National Council of the Judiciary of Poland, who endured a long and exhausting campaign of prosecution and defamation for speaking in his official capacity defending judicial independence. The situation in Spain is different because there are still no final court rulings directly addressing the situation. However, there has been a sustained political campaign targeting judges handling sensitive cases, especially those involving senior officials, those involving the Prime Minister's inner circle, and those involving the 2017 Catalonian referendum of independence. Several executive officials and political allies have publicly discredited judicial decisions, questioned the impartiality of judges, and initiated reforms that reduce the judicial independence, including changes to the selection process of judges and prosecutors just to tame them. There has also been a lack of implementation of some judicial rulings, for example, those mandating that Catalonian schools ensure instruction in Spanish. Parents and children who exercise the right to receive education in Spanish language frequently become targets of harassment. This tactic has a chilling effect, especially when judges face the prospect that the rulings may simply be ignored by the state. Moreover, in this particular case, the non-respect of the judicial decision goes against the children's right to education and to be free from any form of intimidation and discrimination on grounds of their language. These attacks have serious consequences for democracy. Yeah, I'm finishing. I will just say that the vindictive use of lawsuits and selective executions against judges perceived as political inconvenient erodes not only the rule of law, but also the collective rights of citizens to an independent and impartial justice. In the written text, I will add more examples, and I will also focus on presidential pardons and legislative amnesties, and also on judicial reforms. But for the sake of this time slot, I'm done now. Thank you.
Susanna, thank you very much. And that's really important and fascinating. And I think the focus on judicial independence is great, actually, and tragic in a way at this point in history. But these examples from Poland, the US, Hungary, Spain, and places, I think that's a very rich contribution. So thank you very much. And we are next going to Lancaster University. Felix, you're up now.
So the actual title of my paper is Reframing Human Rights Enforcement Through Roles and Goal Framing Theory. Okay, so this is very much a broad view of human rights. So it's not very legal or specific in that sense. But the first thing I note is that many societies have thrived without a human rights code. This is a fairly recent development. And so it is not a condition for a viable society. And so the origin of human rights lies in the claims of the oppressed, not in the legal code. And so to be enforceable, the legal code must respond to a recognizable claim. What makes a claim recognizable in a modern democratic society? Well, I think there are three logics running through this, which are sort of political logics. One is the market logic, which focuses on, above all, on economic claims, and which can impose unspoken conditions on human rights, according to Panica, that exacerbates inequalities. And there's another logic, which is a dignity logic, which focuses on sort of relational logic, really, focus on individual claims concerned with the dignity and worth of the human person. So basically, safety and security, social connection, esteem, mastery, autonomy. And then there is the social identity logic, which focuses on group claims. And this seeks to transform market exchanges into social relations. It's about group identity. So I think there are three different logics underlying human rights. And as I say, human rights are not essential. And it depends, and the validity really, or the ability, it depends on whether they can really capture claims which are recognized by society or recognizable by society. And I think Rawls' theory of justice is an interesting theory about which claims will be recognized by society, and in a sense is a foundation of modern democratic society, I think. So I thought I would use it just to try and discuss this issue. My view of Rawls is basically a market logic, but attenuated by dignity logic. So Rawls and human rights claims. We have the veil of ignorance, which recognizes claims to primary goods unbiased by social, class, or personal circumstances. And that really accords with the dignity logic, I think, in principle. But then we find that there is a difference principle which protects the most disadvantaged, but is subject to the equal basic liberties principle, which prioritizes the higher needs of autonomy, security, social connection, and social connection. But I think this is where Rawls really is subject to the accusation of perhaps falling into a market logic, because it really depends on the person that is under the veil of ignorance, really, as to how far you're going to extend this equal basic liberties principle and undermine wider dignity rights. So if we look at how Rawls' theory is applied currently in America, Well, we have that precisely. These are the claims to security, which is one of the exceptions to the difference principle. The national security is being used to quash human rights claims of immigrants or boats in Venezuela, for example. Claims to autonomy are used to limit claims to medical treatment for people. And so the veil of ignorance through the eyes of the typical MAGA voter would probably overlook race-related claims and claims from non-traditional social groups as well. So I think I sort of think that if you take a narrow view of roles, you end up with a market logic attenuated by dignity logic, but not really dignity logic. I have a couple of quotes here, one from Golda Meir. I don't say there are no Palestinians, but I say there is no such a thing as a distinct Palestinian people. Again, so it's a denial of group rights. And then we have J.D. Vance recently saying, we have no plans to recognize a Palestinian state. I don't know what it would mean to really recognize a Palestinian state given the lack of a functional government there. So, you know, I'm not saying the same thing, but I'm saying that, you know, we can see that there is a kind of ability under the, under rules veil of ignorance, really, to take out to sort of undermine many dignity logic and social dignity claims. Now, what do I say? What do I say of that? Well, I say that because I take the view that human rights are only going to be enforced so far as claims are recognized, and they depend on the people who are under the veil of ignorance. And right now in America, they're very sort of blind to many different types of claims, human rights claims. So the human rights frame is very narrow, and it's very difficult to argue against that, because ultimately, you know, I say there is no, the human rights code is not necessary really for a viable society, in my view. So the goal frame theory is an attempt to say, well, look, rather than focusing on the normative, what you think is right, which is how we often approach human rights issues, focus on self-interest, okay, and try and persuade people who are operating on this kind of market logic, stroke dignity logic, to widen up their approach to human rights by tapping their self-interest. And the goal frame theory has three frames. One is the hedonic goal frame, which focuses on immediate pleasure, and it has a short time horizon. The gain goal frame, which focuses on acquiring and protecting resources like money, time, and effort. And the normative goal frame, which is about substantive rights. And just to simplify this, basically what this means is that hedonic goal frame focuses on acquiring new resources, and gain goal frame is protecting existing resources, really. It's all about self-interest, it's all about protecting my own interest. The normative goes beyond that. It's about recognizing other people's interests. So I have a little example here from, so people will be more amenable to recognizing claims when there is a sense of personal gain or avoidance of loss. A claim may become recognizable by highlighting positive or negative self-interested implications of not recognizing it. And so it looks beyond normative argumentation. I just reflect briefly on the Rana Plaza disaster that happened in Bangladesh a few years ago. That suddenly all the international textile firms were until then had really not taken any interest in the welfare of the workers, suddenly took a great deal of interest, and they made huge commitments. And until then, they had passed responsibility for local labor standards to local suppliers, and also only had used risk management strategies to minimize their liability. When this disaster happened and everybody looked at them, and their reputation was at stake, suddenly became very, very interested in human rights. So we had this transition from building collapse to risk of social reputation, acceptance of labor and human rights claims. So I think that in the context of this paper, or sorry, this issue, which is human rights and digital age, there's a great, and I'm not going to elaborate on this now, but there's a great potential really for using the digital means to precisely stoke that self-interest of many of these politicians who may hide behind the veil of ignorance, really. and maybe approach human rights less from a purely normative perspective, which is increasingly not listened to, and much more from a perspective of the implication that it has for the reputation and the well-being of society as a whole. And that's all.
Brilliant. Thank you very much, Felix. That's very helpful. And I think it's great. We've got a very foundational talk there and about sort of the understanding the origins and reality of rights in some way, and the dignity logic and the market logic, and how the digital world can help grow those claims or deny them, actually, in a sense. So that's very interesting. Thank you. We're going to keep moving on, and then we'll discuss everything together at the end. So the next person is Sonia. So Professor Sonia Boulos. And Sonia, you're going to talk about the International Court of Justice advisory opinion on the occupied Palestinian territory and legal consequences for the EU. And you've made your slides work. Brilliant.
Okay,
And you can make them one stage bigger than that too. Yeah.
Can you see them now?
Yeah, we can see them. That's probably enough. But if you want to click that's, yeah.
Okay.
Good.
Now?
Very good. Yeah.
Okay. So thank you for organizing this. And it's great, sharing this platform with all of you again. Now, my paper started as a focus on the advisory opinion. But with time, it was like shooting at a moving target, unfortunately. I decided to expand it a little bit and to kind of try to focus on all the legal developments that were happening. So in my presentation, I'm going to focus on the genocide case brought by South Africa and its legal implications. I will focus on the advisory opinion, but probably in the final paper, I will also address the arrest warrants and developments at the International Court of Justice, the International Criminal Court. So I made my slides really minimalistic just to help me focus and do it fast. So we all know that South Africa brought a case against Israel in the International Court of Justice, accusing Israel of violating its obligation under the Genocide Convention. The court issued a series of provisional measures, and legally speaking, it means that the allegations that a genocide is taking place are plausible and that there's a real and imminent risk for violating the rights of the Palestinians under the Genocide Convention. So this finding has legal implications. And the court said it in more than one case, previous cases, that the Genocide Convention, I mean the title of the Genocide Convention, it's a convention for the prevention of the crime of genocide. So prevention plays, a key role in the convention. So, and the court highlighted the importance of prevention. And so the minute the court decided to adopt or indicate provisional measures, it immediately triggers the obligation to prevent genocide. Okay, what does that mean? So legally speaking, if the court is warning the international community that a genocide is plausible and there's an imminent risk, one, states must employ all the means reasonably available to them to, prevent genocide. It's enough that if the states know or should have known, and this exists clearly because they have the provisional measures, if states fail to take the measures they are expected to take, this would amount to violating Article 1 of the Genocide Convention that talks about prevention. And in some cases, if states continue to provide weapons to the country that is being accused of committing genocide, this would amount to complicity in genocide, not just simply failure to assist. And the court made it clear that this duty arises not only if the actors who are, allegedly involved in genocide are under its control. It's enough to prove that the state or the, states, community of states can exert influence on the actors, even if they're not directly under their control, to make, to claim that they have a clear duty to prevent genocide. So I already explained that we're talking now about the realm of Article 1, Article 3 between failure to prevent and complicity. So I want to focus on the question of arms sale to Israel. The United States is number one, provider of weapons for Israel, but so European countries come second, for example, Germany. So what is happening now, taking it back to the European Union, I'm going to skip all the reports that talk about genocide, not simply that there is a risk of genocide, because, the UN reports, Francesca Albanese issued 4 reports, the International Commission of Inquiry issued 2 reports, making clear that we're talking about genocide, human rights, Amnesty International, Israeli and Palestinian human rights organizations. And I'm going to just fast forward to the EU duties on arms trade treaty, linking this to the EU. Now, the EU as such doesn't sell weapons to Israel. It is EU member states that some of them continue to sell weapons to Israel, even in the current situation. So the EU is a strong supporter of the arms trade treaty. And it is, pride itself of being one of the, organizations that are highly engaged, with this treaty, trying to harmonize international standards on the transfer and of weapons in a way that respects human rights. So the arms trade treaties have 2 relevant articles for our discussion. Article 6.3, that clearly says that no authorization with knowledge of use for genocide or grave international humanitarian law or human rights violations. So states have a clear obligation not to sell weapons if they know for a fact that we're talking about these kinds of violations. And we have then Article 7, which talk about risk assessment. So it's not about only cases when we know for sure, but in cases that we suspect that the weapons are going to be used to violate international humanitarian law, of course, the Genocide Convention, the Geneva Convention, etc. So what the EU did is to adopt a common position in a way to give more visibility and to coordinate and harmonize the actions of EU states in relation to the arms trade treaty. The common position itself is a binding document. Like it's the legal obligations in the common position, which reflect the legal obligations in the arms trade treaties, are binding. And they also adopt the same criteria about human rights protection, about the duty not to sell weapons in situations of risk. But there's a serious problem with this framework. And Gaza made it very clear that the EU is very limited at the moment when it tries to act as a normative actor. For starters, there's a paradox. While the common position is legally binding, there's no way to enforce it. First, all the decisions that are related to arms trade are outside, the control of the EU itself. Eventually, states are the ones who decide how they're going to enforce the normative framework, because this is considered part of the common foreign and security policy of the EU, in which the EU cannot act as a supranational institution, rather as intergovernmental institutions. Not to mention that the treaty of the EU talks about the right of states to keep secrets. There are some secrecy exemptions that impede transparency in relation to national security. So what happens at the end, that we see divergent national interpretations of the legal framework with zero ability to enforce it. Just to give you an example, in the case of Gaza, we see that Spain, Belgium, Netherlands decided to suspend arms trades with Israel, whereas Germany and France had a different interpretation of the legal framework, and nothing could have been done. Actually, in Germany, arms sale even, increased by tenfold after, allegations of massive human rights violations were voiced against Israel. And also in the case of the European Parliament, even the European Parliament could have symbolic power. There was a complete failure to adopt, resolutions. There were no consensus whatsoever. And even the transparency mechanism that could somehow exert pressure on states to shame them in a way to make, even though there's no way to legally enforce the obligation, did not function at all. The annual reports came too slow, they are too shallow, and we don't know a lot of information that could be used at least to try to shame states that do not respect their international obligations. Now, this is also relevant in relation to the advisory opinion on the continuous Israeli presence in the OPT. Now, the advisory opinion made it clear that the continued presence of Israel is a violation of the right to self-determination of Palestinians. It is a violation of the prohibition on acquiring land by force. It is also a violation of the prohibition on racial segregation and apartheid. So all these violations are included in the prohibition on arms sales. So they are equally relevant when European countries assess whether they can sell weapons to Israel or not. And this, unfortunately, wasn't enough to force or make some states, take their legal obligations seriously. Now, moving from the issue of arms trades into broader legal obligations of the EU, and specifically in relation to trade, which is a different domain. It's a domain in which the EU can act as a supranational institution. We also saw there's a great failure in respecting basic international legal norms. Now, all the violations that were highlighted by the International Court of Justice that I just mentioned are considered what we call jus cogens, peremptory norms of international law. And they have clear legal implications on all international players, including the EU. And this, as a minimum, include the non-recognition of illegal situation, the duty not to render aid or assistance in the maintenance of an illegal situation, and also to remove impediments to self-determination of Palestinians. So what does that mean? In all the treaties that the EU has with Israel, the EU must make sure that it doesn't recognize in any way Israel as a sovereign in relation to the occupied Palestinian territories. It must also make sure that there are no investment, no relations that sustain or aid or assist the continuance of this illegal situation. However, if we look at the case law of the European Court of Justice, we see that there's a misconception about what these norms really implicate. So we have also some sort of contradiction in the case law itself. For example, in one case, in the Air Transport Association case, the Court of Justice says clearly that the EU must adhere strictly to international law. But then in another case, and we know that in all association agreements, there is a provision, usually the human rights clause, that makes it clear that the EU can suspend or even annul a trade agreement or association agreement based on human rights consideration. The court said even if these clauses exist in association agreements, it doesn't mean that the EU must do so. It only means that the EU can consider suspending an agreement or annulling an agreement based on human rights violations. This is a misconception of international law. There's a difference between looking at this question from the perspective of EU law, and this, yes, it makes sense what the court said, that if you have a human rights clause in an agreement, it doesn't mean that states must, follow it. They can, the court can say that. But when it comes to what we call erga omnes obligations and obligations involving peremptory norms of international law, such an interpretation is flatly wrong. It is not a question of discretion that the EU can annul or suspend an agreement in cases involving violations of peremptory norm. It's a clear legal duty. In the only case that...
2 minutes, 2 minutes.
Yeah, I'm finishing.
Well done.
In the only case that, the Court of Justice dealt with that on, kind of, if we want to make it a bit comic, adding some stickers to products that are coming from the settlements in the West Bank and Gaza. at the time. Now, no longer Gaza, there are no settlements, but we never know if this is going to change. So the court interpreted this as, that the EU that, puts this sticker, and it's up to consumers to decide if they are going to buy products that emanate from illegal settlements or not. So all this is a clear violation of international norms. Unfortunately, in the last attempt to review the agreement with Israel, which started, in 2025, there were some attempts to suspend the agreement, but unfortunately, these attempts failed, and there was a lot of critique, even about the terminology that was used. Terminology that there are some indications that Israel is violating its human rights, obligations or international human rights standards. Some indication when you have, undisputed evidence that it's not some indication, that it's really beyond a question that Israel is involved in a serious violation of international law. So unfortunately, this ended with no results, meaning that the agreement continues and nothing is going to change. And here I will stop. Thank you.
Sonia, thank you very much. And that's a really good case study, actually, of the challenge and, in your view, the failure of international law in this moment of time. So it's not quite erosion like Susanna, but more like sort of paralysis and failure. Thank you very much. We've got our last speaker now, which is Kleis. And sorry, I'm just going to find your title, Kleis. And then we've got Carlos, who's after that. So Kleis, you're going to talk about protection of fundamental rights through external trade relations. And you're talking from Stockholm University, which is great. Thank you.
Thank you very much. Signing on here from the cold and dark north. So I'm happy to see you in more light here online. Well, thank you very much, Professor Slim and Professor Espaliú, for organizing this seminar. And I had developed my topic a little bit since I presented it last time. So my new title that I hope captures my contribution is Third Country Social Media, Human Dignity and the Formation of Public Opinion. So when it comes to social media, I think the distinction between the internal and external dimension of e-commerce has collapsed in a sense. We are regulating social media within the European Union, irrespective of where the providers are located. And of course, the big players are located outside the European Union. So the effect of the internal regulation is more severe for companies established in the US and in China. I will try to share my slides here actually. Oh, because I don't see it. Okay, I hope you see the slides. I only see a Zoom sign here on my screen. But anyhow, I think the starting point when it comes to regulation of protection of fundamental rights online in general and regulation of activities within the European Union and also in external relations is the so-called, what I call the methodological source code or the unification process. So I just to briefly present the background. I think Article 5.2 in the TU is a starting point, requiring the Union to always take the objectives of the Union into consideration in all its measures. And we find the objectives in Article 3, Article 3 of the TU, and in Article 1 we have the requirement to always promote the values of the European Union, and we find the values in Article 2 of the TU, and of course, among other things, we find human rights, which has been reconceptualized as fundamental rights under the EU Charter, and according to Article 6.1 in the TU, the EU Charter has the same legal value as the treaties, which makes it primary law. In brief, this means that we always had to take the EU Charter into consideration. Whatever measure the Union is doing, it can be assessed in relation to the Charter, and if it does not comply with the Charter, it is a basis for revocation, and then member state can bring an action against the Union for revocation of this measure. This is a very structured and normative approach, but this is how this is the starting point for my analysis. So in the In the Charter, we find Article 16, the freedom to conduct a business and property protection, which is of course a starting point for all these providers of social media. They have a freedom to conduct a business in the European Union and protection of property. On the other hand side, we also have provision of dignity in Article 1, which is really foundation for all human rights, not necessarily fundamental rights, but all the human rights are, so to say, anchored in a concept of dignity. This is something new since 2009 in the Lisbon revision, because before that, the human rights, fundamental rights appeared as a ordre public justification in EU laws. It was based on social order, so to speak. But now dignity is a starting point under Article 1 in the Charter. It's specified when it comes to privacy and data protection, which is of course topical when it comes to online activities. Now media freedom is also moving into the limelight. And we also have the economic freedoms and property protection for other market participants, and not the least when it comes to intellectual property rights and like copyright and so on and so forth. So these conflicting interests are reconciled under Article 52.1 of the Charter, saying that any limitation needs to be provided for by law, and all these rights and interests, they can be limited if it's necessary to recognize also other rights, freedoms, and social interest on a basis of proportionality. So that is how you ensure consistency of the European Union legal order. And again, this is the yardstick for assessing good law under the European EU law regime. So you can revoke any action, bring a legal action against a union measure that is not, to speak, in accordance with this structure of fundamental rights under the EU Charter. We have also provisions on external relations under Article 3.5 when it comes to the objectives of the Union, and Article 21 requiring the Union to always strive for consistency in external actions with internal measures. But this is not necessary when it comes to these online activities because, as mentioned, it's internal market law, as simple as that. This distinction between internal and external measures collapses online. So, on basis of this, of course, the main legal framework nowadays is the Digital Service Act, and it just reiterates what I just said, that this regulation shall apply to intermediary services offered to recipients of the service that have their place of establishment or located in the Union, irrespective of where the providers of those intermediary services have their place of establishment. So, geography has little interest if the data subjects, let's say, are in the European Union, the recipients are in the European Union. So what about the substantive law here? Well, the intermediaries, of course, are liable for actively taking part of the provision of media content, I mean, like everyone else, of course. And this concept of active provision is very technologically dependent on what machines can do and what you can require a machine to do. So, of course, this is relevant to mention, at least at this point, that there's a general activity threshold here to take into consideration. If it's just an intermediary service, a hosting service, there's no liability for the intermediary unless the service provider has actual knowledge on illegal activity or illegal content on the platform, and when obtaining such knowledge or awareness does not act expeditiously to remove or disable access to legal content. So this also harmonizes because of the harmonization requirement under Article 7 in the TFU with other legal measures, for instance, when it comes to IPRs. But it's important also to remember at the same time that under Article 8 of the Digital Service Act, it is recognized that there's no general monitoring obligation. As a matter of fact, monitoring of media content providers is prohibited under Article 15 of the e-commerce directive. However, there's a proposal for chat control underway, which will require the platforms to also monitor child abuse content on the platforms. So there's a limitation of this freedom from liability when it comes to monitoring. And then, of course, large platforms have more requirements that they need to fulfill. Interestingly enough, why I go through this again is that 2 weeks ago, the European Commission issued decisions against TikTok and Meta for lack of transparency in accessible notice and action mechanisms difficulties for research to access the data. So it has teeth and is, of course, a geopolitical dimension to this. I hope you see that I'm changing slides because I can't see it myself here on the same screen as I see you. But now we move on from this general legal framework for when it comes to liability for platform providers, social media providers, to competition law, which also has proven to be a useful tool to protect fundamental rights online in this digital environment. We have the case C252/21 Meta platforms versus German Competition Authority, which, to make a long story short, clarifies that you can use national competition law and also EU competition law to ensure that, well, it simply is an abuse of dominant position not to abide by the requirements under the GDPR. And of special interest is this genuine choice requirement, which is an aspect of consent. Of course, if you can tick a box saying that I consent to share my personal data, but it does not suffice if you do not have a genuine choice to access some services without sharing all your personal data. So this is a development which is also manifested in the Digital Market Act nowadays. And this applies not only to data protection, but more broadly to fundamental rights. It is stated in recital 109 in the DMA. This regulation respects the fundamental rights and observes the principles recognized by the EU Charter. In addition to this tailored legal framework for online or social media or platform provision, DSA, and the competition law aspect of this digital markets DMA, we also now have a new regulation that took effect this summer, namely the Media Freedom Act 2024-1083, which is a framework, again, it's a hybrid between different, so to speak, competence of the European Union on the internal market. But it's about promotion of media pluralism, independent media, repression of mis and disinformation. And this is also in collaboration with the online platforms, large online platforms. So you make the platform providers also regulators. And of course, this is not very popular in the USA, and even Donald Trump has intervened and encouraged the American platforms not to abide by these new European standards for protection of fundamental rights online. But we will see how it goes, because of course, at the end of the day, the Commission can impose a fine on these companies, and it has already done so in other aspects of the internal digital market. So we will see what happens. But this is at least where EU law has teeth, so to speak. So what I'm working on now, the development of my contribution that I hope I will finalize in foreseeable future, is the study focus on the responsibility of social media providers to ensure human dignity in connection with the formation of public opinion on the editorial responsibility. Here's where the Media Act comes into the picture, and also promotion of human dignity in connection with the formation of public opinion without editorial responsibility. And this is, of course, somehow monitoring, ensuring how to reconcile freedom of expression with human dignity. And of course, the case in point here is racial and hate speech and all these kinds of things. So I will try to just provide a structural analysis of this based on dignity, instead of as the original approach based on the social concerns. So that is kind of the philosophical basis for this more systematic approach. Well, I hope you follow my drift, and thank you much for your time so far.
And Claes, thank you very much for sticking to time. Another great example of great timekeeping. Thank you all. But also really, courageous of you to go right for the topic itself and focus hard on the law and dignity and human rights and all those aspects that are up for grabs now. So thank you for that. And then we'll go to our last speaker, who is Carlos Espaliú. Carlos, great that you're doing this too. And as our leader, you're going to talk on St. George and the New Dragon, the fight of the European Union against disinformation sponsored by states. Thank you.
I said thank you very much, Hugo, and the Las Casas Institute for letting me organize this workshop with these important contributors in order to promote the defense and the importance of human rights in this world crisis and this problematic era. So as a sort of introduction, I will start by saying that the use of false information is inherent in the human condition and has historically been employed for political, economical, or even military purposes. But the problem today, that this issue, that this phenomena has achieved the extraordinary dimensions due to the technological revolution. It has become a global risk when it takes the characteristic of disinformation campaigns. For me, this information disorder, disinformation campaign, can be defined as the orchestrated dissemination of false, of untrue news or data through any type of communication channel, whether traditional, printed press, radio, television, or horizontal, for example, social network, etc., with intention of gaining an economic, social, or strategic advantage, or harming rivals, be they individual societies, institutions, or states. I have focused in this article in the geopolitical landscape because, as you can imagine, all the states, but also all the international organization and the European Union itself is suffering gigantic disinformation campaigns. And we are going to study in this article the fight of the European Union against this new monster, I would say. The seriousness of this threat cannot be underestimated, mainly when you see that they can affect fundamental rights that form the basis of our European democracies. For example, the right to free and fair election, the right to free from unlawful attacks on one's honor and one's reputation, the right to non-discrimination, and the right to privacy. But also, we have to take into account that it's very difficult for Western democracies to fight against this plague of disinformation campaign, because for fighting against disinformation campaign, you can affect as well the right of free information or the right of expression. So you have to be very careful. The states and the international organization, they have to be very careful not to affect themselves those rights that they are promoting or defending. They can affect those rights as well when they are fighting against this disinformation campaign. That's very difficult then for European or Western democracies that they try to defend and to promote those kind of rights. But also, in addition to affecting human rights, the disinformation campaigns can amount to interference in the internal affairs of European Union members and the European Union itself. And there is a tendency to consider those disinformation campaigns as an element of hybrid war, and therefore to amount to a violation of the provision of the use of force in international society embodied in Article 2.4 of the United Nations Charter. As probably you are aware, NATO had already in 2016 set forth that it could invoke Article 5 of the Washington Treaty in the presence of hybrid warfare, and I quote the NATO words, where a broad, complex, and adaptive combination of conventional and non-conventional means, and overt and covert military, paramilitary, and civilian measures are employed in a highly integrated design by state and non-state actors to achieve their objectives. So for NATO, the use of disinformation campaigns together with other elements can amount to the use of force, and then in presence of those campaigns, NATO can invoke Article 5 of the NATO Convention. And a possible future consideration in my research is whether international organizations should be permitted to use self-defense in response to a disinformation campaign, whether alone or in conjunction with other factors, if it is deemed to constitute an armed attack. This is to begin with this discussion. I would like to express my belief that the question of whether a disinformation campaign should be considered equivalent to an armed attack should depend on the damage caused. I think on top of that, the opportunity to study this topic is quite relevant. If we see that in the foreword of the third European External Action Service report on foreign information manipulation and interference threats, FIMI, the EU High Representative for Foreign Affairs has said that our information space has become a geopolitical battleground. Taking into account all those aspects, I structured my paper. As you can see here, the first session will be after the introduction, the paper war, all this, the initial period in which the European Union took not very strong measures and policies against disinformation campaigns or orchestrated by foreign state. And the third session will be the real war. So after 2022, the European Union has moved on to take on more stronger measure and policies against disinformation campaigns, and we will, at the end, I will put forward my conclusion. To start with the paper war, so you have to consider that this new plague of disinformation campaigns started, let's say, around 2015, when the European Union started to be aware that Russia was using disinformation to damage the European Union members' rights, values, etc. At that time, the European Union, as they were the member state, they were a little bit without weapons to defend themselves. They have to start to set up policies, measures, and so on. And then the first measure or policy that the European Union set up was the creation of the East Stratcom Task Force in 2015. This Stratcom Task Force is a platform to develop, to create, to promote correct information in the eastern countries of Europe in order to counteract the influence of the Russian disinformation campaign. It is still existing nowadays. But the most important event, in my opinion, that took place at that initial years was the creation by the European Commission, of a high-level expert group on disinformation that gathered, and in March 2018, they put forward a report, which is the base of future policies and measures of the European Union since then. That report of experts recommended the use of non-regulatory measures, non-regulatory policies, not highlighting control mechanism, but promoting the interaction between stakeholders, alphabetization of the public opinion, etc., journalists, and not strengthening the regulatory aspect of European law. Based on this recommendation by the high-level expert group, the European Commission promoted a code of principle of disinformation, and the main European platforms in 2018 set up the code of practice of on disinformation, which was instrumental at the beginning of the fight of the European Union against disinformation. This code of practice of 2018 highlighted transparency in political advertising, defended the necessity to closing false accounts, of preventing disinformation providers from monetizing their content, and it was open to signature in some month afterwards that it was written, and in 2021 it was signed by main operators in the European Union. But it was highly criticized because it relied on very weak instrument. There was no control, there was no fines, there were no sanctions, and the result was, of course, very, very poor. It was criticized by everybody, let's say, by the both official institutions like the European Union bodies, but also for the academia, and the literature. Also, the European Union learned very important lessons from practice, for reality, mainly through the pandemic in 2020-21, and also of the Russian invasion of Ukraine. And then the European Union put forward stronger measures in order to fight these disinformation campaigns. Everybody agreed that it was necessary if the fight against disinformation should succeed. It was needed more stronger measures and policies, and that's why I think we moved forward to the third slide or part of my intervention, the real world. First, on the EU response to disinformation campaigns in a context of growing rivalry and foreign hostility. As I said before, the pandemic and the invasion of Ukraine by Russia learned the European Union members and the European Union institution that they should adopt a stronger measure of policies. Otherwise, we will be in the mercy of Russian campaigns. No? The first measure that the Commission adopted was to a reformation of the Code of Practice on Disinformation. A new version was adopted in 2022. It is called now, you see, Strengthened 2022 Code of Practice on Disinformation, whether it consisted on a stronger monitoring and sanctions regime, and mainly it was linked, or it is linked, to Digital Service Act, DSA, which has other hard law norm, like Regulation on Political Advertising 2024/900. Because of that, because of the link of the Code of Practice with this hard law regulation or norms, the possibility to put fines and has been increased, and now if the platform companies, the big platform companies and other actors doesn't fulfill their obligation contained in the Code of Practice and in the DSA or the Regulation on Political Advertising, they can face important fines. For example, the 6% of their worldwide turnover in preceding financial year, which are very strong fines. So far,
We've gone over time, so 2-3 minutes. We are
okay. Thank you very much. So far, the European Commission has started several processes of control of these big platforms, but so far we don't have any fines imposed yet. Together with that, also due to the dimension on the European security of those disinformation campaigns by Russia, the European External Action Service has taken the protagonism in this fight against disinformation campaigns. And after the strategic compass of 2022, they have started to adopt a stronger measure with more teeth in order to counteract the influence of Russia. For example, in 2024, it has been set up the EU sanctions regime, and so far about 40 individuals and 9 entities linked to Russia has been sanctioned. For example, the individuals, they are not allowed to travel into European territory, or the companies can see their asset freeze. Also, the EEAS has imposed broadcasting restriction, and so far 27 currently backed media outlets has been suspended, etc. Though for the future, I have discussed in my paper. You have it in the written form, the possibility of using the force by the European Union against the disinformation campaign when they amount to armed attack. Let's say if the European Union can have recourse to self-defense. This is a very new topic. First of all, we have to see if the international organization can have recourse to self-defense. I think that can be replied in the affirmative, seeing the position of the International Law Commission in 2011 report on the responsibility of the international organization. But I would say it is very difficult to imagine an armed attack or a disinformation campaign that can amount to armed attack only to the European Union. It would be very difficult to see that. Normally, any disinformation campaign that should direct the European Union should also affect the European member states or territory. And in that case, I think more probably the member state can have recourse to Article 42.7 and respond to any attack or any disinformation campaign that can affect either itself or the member state. But I don't see the European Union in itself being the target of this information campaign amounting to an armed attack, I will say. So I will stop here. Thank you very much.
Thank you very much, Carlos. Another very practical chapter, really focusing on changes today, and are we talking about the equivalent of an armed attack? Where does this stand in relation to warfare in a conventional way? So that'll be an important chapter too. So I don't know how you want to do this now, Carlos, but we've got 5 good and different papers there. So we've got one on sustainability and how we relate that to digital sustainability or whatever. I'm not sure yet. One on the erosion of law and judicial independence and seeing how that is manipulated in digital space and perhaps can refer to digital space and the lawfare around it. Then Felix's foundational paper on how do we recognize claims in the digital world, and how does digital space deny or create those claims, or stoke them in his words. And then the important Gaza case, looking at the very specific case of Gaza and in international human rights law today for the EU and the EU's obligations in terms of its own treaties and in international treaties. And then Kleist really focusing in on EU law to look at what the Charter and Digital Service Act really has to say about people's rights in digital space. And then you're on basically interstate digital space and what we can do to protect that, and what qualifies as a genuine forceful attack through informational space in some ways.
Before I leave, because I have to leave now, I'd like to express my congratulations for the high level of the position submitted. In the area of human rights, I'm not a great expert, but I think there has been significant progress in the substantive sphere. Being a lawyer myself for a long time, I see that there's a great process on the material law, but I hardly see no progress, or little progress regarding the use of the courts of those seeking for justice. Because this is not accompanied by sufficient legal aid resources for those who are particularly vulnerable from the economic point of view, we will be having fundamental rights, of course, but in a way like charters granted by autocratic regimes. But we will not have a rule of law worthy of the name in the Western world if we don't give the economic means for people to defend themselves and acting these fundamental rights by themselves. That's what exactly the little thing I just wanted to remark before I leave in a couple of minutes. So thank you very much. Thank you, Carlos, for joining, for letting me in. And okay, it's been a wonderful experience to share this conference with you all.
Thank you, Enrique, and thanks for your comments and thanks for being here. Borja, you've been patiently listening, and Scott as well. So any questions? Let's take them, or observations.
First of all, I want to compliment everyone for the high quality of the papers. I think that is very good going into for all the work that Carlos now has to do with putting it together. And so as I've been listening to everybody, I have been thinking about this issue of coherence, of how does it fit together. Now, how it may fit together for me may, of course, not how it fits together for all of you, but I am at least going to share how it perhaps fits together for me, or it could fit together for me. And that is coming from Pope Francis. And it does very much touch, Carlos, on your own paper, and that is simply that Pope Francis has argued for a long time now that we're actually stepping into a third world war piecemeal. And the point is, what is war and what is the piecemeal? But that direct, and this notion that that the different dimensions that you're all talking about relate perhaps to what that war is like in the 21st century. Now, the idea that it's by fighting it, that it's battleships and all of this is very last century. And that's why the talk about human rights for me, the issues of sustainability, the core elements of the EU, of what's important is also, quote, a way of fighting that war, if you will, non-violently, if you want to argue that we're in an age of totalitarian terror and dysfunctional democracies.
Scott, thank you. That's okay. Helpful framing. And then you've got lawfare, warfare.
That's
religion,
right.
Everything.
If I'm one more thing is, I don't know whether this is useful. Far be it for me to say this, but in that framing, I actually think it's rather marketable.
Yeah. Good. Okay. Thank you. I'm sure I'm saying your name wrong. Is it Borja or?
Yes, in Spanish it's Borja, but Borja is okay. Hugo. Good afternoon, good evening to everyone. First of all, thank you so much to Professor Carlos Espaliú for the kind invitation to participate in the workshop this afternoon. I have to admit that all the presentations of all your papers have been amazing, outstanding, because I have learned so much with you all. I'm quite sure that the monograph that will appear in Cuadernos de Deusto will be amazing. So congratulations to you all. Just a short note on Carlos' presentation, because I have still a brainstorm of ideas in my mind. Completely agree with Carlos' presentation, because I totally consider that disinformation is one of the most important threats that we are facing nowadays in Europe, more than nuclear weapons or possible acts of aggression that possibly Russian Federation may commit, not only against Ukraine but also against other countries. But I don't know if maybe Professor Carlos Espaliú can consider that a real sanctioning mechanism at EU level could be implemented in case some EU member states don't comply with their obligations on misinformation and countering misinformation, because we see that the strategies in 2018, in 18, as you rightly said, there were no sanctions or mechanisms, but there are already tools that have been implemented in 2025. Do you think that we can see a mechanism on this in the short run, in the medium term? Thank you so much.
Great, thank you. So, who wants to respond to those? I mean, Carlos, do you want to respond first, and then others can chip in?
Yes.
So,
thank you, Borja, for your question and being present in today's session. As I said, the European Union has so far implemented a system of sanctioning, but it's of course foreseen for against foreign intervention from foreign states, no, and individuals or companies or entities of foreign states. There is no so far there is no sanctioning system against European member state for not respecting their rights or their obligation in connection with the fighting disinformation campaign. I don't see that coming soon. No, I think the system now implemented is only refers to imposing sanctions or fines against foreign individual or foreign entities or companies. I don't see a sanctioning system against the European member state so far. At least a new system focused on the non-respect of my member state of their obligation in fighting disinformation campaigns. I don't see a specific system or procedure to impose sanction on member state on that. That's my opinion. I don't know what the other can think about it.
Sonia, Kleist, anyone else? Lawyers? Felix, I'm excluding you. You're just a legal theorist.
Thank you.
Sonia.
I mean, probably the mechanisms that exist, like international law tools that exist to fight disinformation in general, could be also used, in relation to specific countries within the EU. For example, there are a lot of debates how, intervention in elections, whether it violates the UN Charter, whether it violates the right to self-determination of people because you're pushing people to make decisions in a fraudulent way. So I assume you have to look to a broader kind of lens. But I raised my hand to go back to the original, if that's okay with
Yeah.
I mean, my own, whether we have a common thread or theme within all the presentations, mine by far is the one that did not, among the few ones that didn't mention the digital era at all. But I was thinking about, I did partial presentation of what I wanted to say. The first part of the paper is going to be dedicated to the theory of Europe as a normative power as a sui generis organization, the Jan Manners, theory. But I think it relates to it. I mean, after doing the legal analysis, how the EU is miserably failing, that the reputational damage here I might, link it to the digital kind of aspect, that the reputational damage now with students, young people having access to all these platforms is way more noticeable compared to 20 years. I don't know any young student, activist or not, who do not know who is Ursula von der Leyen or Joseph Borrell in the last 2 years, because they have seen, kind of TikToks about them, and that we wouldn't have seen this 20 years ago. So the point that I'm trying to make here is that the reputational damage for the EU, when Borrell has this discourse saying that Europe lost its soul in Gaza, is amplified by the digital. So it's something that is becoming more accessible to the, EU constituency and beyond. So the message is being amplified enormously, and the reputational damage for the EU. So I think this is also one way of understanding that what you're doing, like to send a clear message. It's not just, some academic debate and exercise about the EU as a normative power, but it's way broader, that it's going to have, I think, for the long run, serious implications for the EU, the loss of credibility and, in certain circles and beyond the borders of Europe.
So it's sort of digital denorming.
Yeah.
Is it sort of denorming that the institution via digital space and reputation? Thanks, Sonia, that's great.
Yeah.
Klaes, you've got a thing. Should we make this the last one? Because then we can make a plan.
Yes, I think it's late. We can go for the last question, or if there isn't, we can stop here.
So, Klaes?
Well, okay, thank you. I don't want to take too much time, but
Okay.
I think the Union is rather clever about these things, because if you change gear and speak about foreign and security policy, that's another ballgame. Callas team, so to speak, they are operating sometimes off radar, so to speak. But the Union main approach to all this is actually a market regulation approach, and they bring a lot of aspects into these DSA and DMA frameworks now, and a new legislation as well. So they kind of reduce the tensions and the level of kind of blaming and with the internally and external relations. So I think they're doing a great job to make this, neutralize this as a market aspect mission, actually.
Thanks, Klaes. Felix, do you want to say anything before we stop and Carlos rounds us off?
No, I have learned a lot from everybody. I'm obviously not, as you say, I was a lawyer once upon a time. I was in Oxford once upon a time, but I've changed completely and do marketing at the moment. And this is part of my ethics kind of side of things, really. So I've learned a lot about some of the issues that are happening on the legal scene. I just think that it might be a good idea, I think, to try and wrap around this notion of digital era that Carlos has sort of mentioned, somehow to try and make some reference to it in our papers. I mean, it's only I will in mine, obviously, but I think it's a worthwhile topic. I mean, obviously one of the papers precisely on that, but I think there's some way we need to think about what is different about this era about human rights, because we tend to get very fixed ideas of the 1948 Convention of Human Rights and how it all should run, but maybe things are changing a lot, and that should be reflected.
Brilliant. Felix, thank you. And I think that's a good point. So I think there's work to do on theming the papers together and getting that coherence. And you've got suggestions from my Scott and Sonia and others and Felix. Carlos, do you want to just end us off, because we should stop now, I think. So next steps.
No, I thank you all for gathering together today. I also learned a lot of your contribution. I would like in the end to thank Hugo for hosting us in the institute. I think that is the purpose of the Las Casas Institute: promote the defense of human rights theoretically and practically. I think Hugo himself is doing a very good job in defending human rights in the practical arena, not only in the theoretical arena. That's very, very, very interesting.
So thank you all. I've learned a lot too, and it's lovely to think with you all this afternoon.